Well, good morning and welcome to our Broker University webinar. Arizona Realtors is proud to bring you this monthly webinar series designed exclusively for Arizona brokers. Give us 1 hour on the third Thursday of each month and you will gain valuable insights to make your brokerage and our industry more successful. I'm Callie Waterhouse with the Arizona Association of Realtors, and today's Broker University webinar is all about unlicensed assistance and activity with attorney Richard Mack. And we're very, very honored to have Rick join us. As always, today's presentation will be about 45 minutes to an hour. I think Rick is going to take some questions during his presentation today. So we definitely encourage you to use the question box feature on your screen and ask your questions, because, you know, we get this opportunity to have Rick here. And if you have questions, he is our go-to guy. So we welcome your questions. All right, so Richard Mack has been a lawyer since 1990, is the State Bar of Arizona certified real estate specialist, and has the designation as the 2008 to 2012, 2014, 2015, 2016 super lawyer. Isn't that a title we would all want to have? How awesome is that? So Mr. Mack has defended professionals including architects, appraisers, attorneys, contractors, engineers, escrow agents, home inspectors, insurance agents, mortgage brokers, and real estate agents in more than 1,000 civil litigations in every county in the state of Arizona. Wow.
That just means I'm old.
I'm going to go with experience. So what we're super excited though is Rick is one of our risk management instructors here at AAR. He teaches the RCRMS classes. So really is our go-to person. And he is also he works closely with general counsel for AAR on various industry issues, and he's the lead attorney for AAR's legal hotline. So Rick, with all of that, welcome today.
Thank you. Thank you.
We are super excited that you are here. Folks, today's webinar is being recorded and will be available on our website with all of the other webinars we are doing. And of course, at the very end of today's webinar, there is a survey. So if you would give us your feedback and let us know your thoughts and how it went and what we could do better, it would be greatly appreciated. So with that being said, Rick, welcome.
Thank you. And with the survey, be kind. This is my maiden voyage on a webinar, so I don't know. I'm used to seeing faces and interacting in person, so hopefully I can make this fly. In terms of what I'm going to talk about today, I want to give you a little bit of the why, and then tell you broadly what we're going to cover, and then kind of dive in. So the why. Why unlicensed activity? Why is this something we need to at least be aware of? Several reasons. If you're like me, every time you get that ADRE bulletin, you go to the violations and the consent orders and the punishments, and you look to see, number one, who's in trouble, and number two, what they did. And if you take a look at the last 6 to 12 months or so of those publications, unlicensed activity is a fairly common topic of what the department is looking for. Why they're doing that, I can't tell you. I'm not going to opine. I don't know. But I can tell you that it's something that's pretty hot. That, advertising, and property management are all fairly common topics. So why unlicensed activity today? Number one, the DRE is looking at it. I think that's pretty important to everybody, for everybody to be aware of. Number two, Callie talked about it a little bit. I'm on the hotline for the Arizona Association, and we get about 400 calls a month. It's about 20 a day. So we're kind of the leading economic indicator of what's hot in the industry, and we get a lot of calls on unlicensed activity. What precisely can I do, and who's going to pay these people? So those are the primary issues that we see under that topic. So again, it's hot. I get calls on it during the day, and it's something I need to be aware of and something I deal with fairly regularly. And then finally, I have the privilege I'm going to call it the privilege of defending a lot of brokers and agents at the ADRE. In fact, I'm going to the ADRE today after we're done here to deal with an issue. And a lot of those investigations and a lot of those proposed disciplinary actions are based on unlicensed activity. So it's fairly hot, it's fairly common, it's something we need to be aware of as we move forward. So that's the why. That's the why this is an issue. In terms of what we're going to talk about, I'm going to talk about first what is licensed activity, because we need to define the universe of what licensed activity looks like before we dig into unlicensed activity. And then we're going to talk some specifics about what an unlicensed assistant can and cannot do, because it's really easy to state the rules. It's really easy to read the statutes and read the regs. But when it comes time to apply what that really means, can you unlock a door? Can you give square footage? Can you do all sorts of other quasi real estate related matters? That's where it gets more difficult. And I'll tell you, there's no real clear-cut answer. The easy way to go if you're looking for a default is if your assistants are licensed. It makes it a whole lot easier. But if you have unlicensed assistants, there are some very strong do's and don'ts that we'll go through. So that's the outline. That's kind of 30,000 foot level of what we're going to do. And as an introduction, if I could start with the definition of what a real estate broker is, and there are a lot of words on that page, and I apologize, and it's there for a reason. I'm not going to read all of that to you. I am going to summarize some of it, but let me tell you what the purpose of this definition is. This is taken directly out of the statutes. It's ARS 322101, subsection 48, and it's A through P. So there are 16 different items in there in terms of what a real estate broker does. This is a go-to statute in terms of what real estate licensed activity looks like. What is it? And I'm going to run through some of these, but the point I want to make with all this is it's very broadly defined. The activity which requires a license by statute is very broadly defined. Almost anything having to do with a real estate transaction or a listing or collecting rent, so on and so forth, is defined by statute as real estate activity. So that means that the unlicensed activity that your folks can engage in is pretty small. It's pretty narrow, and that's the purpose of giving you this statute. It's in the books. If you look at the Commissioner's Law book, it's in there. It's in there. If you want to look online, it's in there. But this is a definition, and I want to run through some of it just to give you a flavor of what it looks like. So real estate broker means a person other than a salesperson who, for another and for compensation. So those are the key words: for another and for compensation. And then there's a laundry list: sells, exchanges, purchase, rents, or leases real estate, business and business opportunities, or timeshare interests. So you're selling or exchanging. Offers to sell, negotiates or offers, or attempts or agrees to negotiate. So not only negotiating, but attempting to negotiate is covered. Lists or attempts to list, auctions or attempts to auctions, buys or sells or otherwise deals in options and real property. G, collects rent. I mean, it's collects rent or attempts to collect rent or agrees to collect rent. So very, very, very broad in terms of what you do. So not only performing the activity, but agreeing to perform the activity and attempting to perform the activity. So if you attempt to collect rent as a non-licensed person, i.e. you make the call and say, hey, your rent's late, that's by statute under subsection G, practicing real estate. And then the broader one, I'm going to skip over to subsection I, because that's the catch-all, and that's the one that the department usually uses, Department of Real Estate usually uses when there is something that's not quite within the other laundry list, but this comes up. Assists or directs, nope, not I, J, my fault, J. Assists or directs in the negotiation of any transaction calculated or intended to result in the sale, exchange, or leasing or rental of real estate, business opportunities, etc. So assists or directs. What's assist mean? That is incredibly broad. That's the catch-all. That's where the department typically hangs its hat in terms of what these issues are. And again, I'll give you my default is almost anything relating to a transaction having any substance is going to be the practice of real estate, and you're going to have a licensed person do it. So again, the point of all this, there's not a test on what all this is. The point of all this is it's a very broad definition, and subsection J is effectively a catch-all that encompasses a lot of activity, and there are a lot of brokers who make innocent mistakes not realizing that the activity is prohibited, and they do it because they have their licensed assistants called to collect rent or called to do any number of other things. So we'll talk about that as we go through. So that is what a real estate broker is. That's effectively by statute what the licensed activity is. So by definition or by exclusion, unlicensed activity is everything else, and that's pretty narrow. One more point before we move on. We defined a broker in 32210148. Salesperson is 32210152, and it's the same thing. The same definition applies, except it's a person other than a broker and who holds a license who performs the activity identified in 32210148. So whether you're a broker or a salesperson, doesn't matter. The definition, that broad definition I talked about in 32210148, is what is a licensed activity, or is what constitutes licensed activity. So hopefully that makes sense. That's sort of the definitional section in terms of what we need to talk about. Now, the other questions I get: to whom may a broker pay compensation? Also defined by statute: actively licensed salesperson, associate brokers, and brokerages. Pretty simple. Notice what's not there is unlicensed assistants. And we'll talk about who's going to pay and who has to pay by IRS regs and by the Department of Real Estate regs shortly. But look at that and see on there that brokers may not pay unlicensed assistants for real estate activities. And if you think about it, that makes sense, because unlicensed assistants cannot legally perform real estate activities. So again, licensed person, associate brokers, brokerage. One more piece on that before I move on, and this is a fairly common question, and it's not the unlicensed assistant that you typically think of, but here's the scenario. Agent signs or brokers a contract, gets it in escrow, gets through the inspection period. Close of escrow is going to be, let's call it December 21st. They let their license lapse by inadvertence or intention, either one. The license lapses on December 15th. Can the broker pay those people a commission? Technically, they're not licensed at the time of closing, so the hyper-technical argument is going to be no, they can't, because they're not licensed, they can't receive a commission. The department is fairly pragmatic in that circumstance, and if you have lost your license because you intend to lose it or some inadvertence, typically they will allow the broker to pay that licensed or formerly licensed person a commission. If the department comes in and takes your license under a cease and desist or something else, it's going to be a different story. But as a general proposition, if you voluntarily let your license go and there's a commission from a transaction that you were working on while licensed, the broker can still pay that person. And the theory there is the services were rendered and the commission was earned while you were licensed. So even at the time the escrow closed and the money's coming out, didn't have a license isn't going to affect much. So that's the unlicensed activity that I get a little bit on the hotline, and I see a little bit with the department. And in fact, in Tucson, there was a fairly active agent just this fall who let their license lapse, and there were a dozen or so different payments to the person, let the broker's license lapse. And we had some issues in terms of how we were to handle that, and worked with the DRE. They were fairly pragmatic, and the brokerages that paid the non-licensed brokerage a co-broke weren't given a free pass, but at least it wasn't too much of a slap on the wrist. So those issues are out there. The question I also get, and I'm a little bit off topic with what you're expecting, but let me finish this up. Do you have a duty to verify your co-broke agent is licensed before you cut the commission check? No. Or before you authorize title to cut the commission check? No. However, if you are aware that a broker has lost his license, you need to make sure you at least bring that to the title company's attention. All right? So that's the definition of who you may pay. I think we have a question next. We have a poll question coming up.
We have a poll coming up. All right, so we're going to actually make this like a formal poll. So on your screen, may a broker pay compensation to an unlicensed assistant based on the sale or lease of a property? Yes or no? Thank you. 100% no.
Good. Perfect. That's the right answer. You may not pay an unlicensed assistant based on a closing or output. If you have an unlicensed assistant, you need to pay them based on them performing their work. Typically it's hourly, but again, unrelated to real estate activity, unrelated to closings. This question raises a couple more issues that are also hot that I just want to talk about. And one deals with everybody's favorite topic, the IRS, and another deals with the Department of Real Estate. So Kelly gave me a disgusted look on the IRS. Yeah, all I know about the IRS is I don't like them because they charge me too much money. With the IRS, there is a exemption in the code whereby real estate agents are not treated as employees. So the broker does not withhold taxes, the FICA match, all of that stuff. And the exemption in the code, the Internal Revenue Code, is based on things very specific to licensees. And they are, if the person, number one, has a license, real estate license. Number two, substantially all of the compensation is based on sales or output, not on hours in. And number three, there's a written contract between the brokerage and the agent identifying that the agent will be treated as an independent contractor, not an employee. So you need all three of those to, as a broker, to not withhold taxes and to treat the person, the licensee, as an independent contractor, not an employee. And I'll run through those again. They have to be licensed. Compensation must come from closings or output. And the written document between the brokerage and the agent must identify the agent is a non-employee. So if you meet those three, then the broker need not do the withholding. The broker may treat the agent as an independent contractor. Virtually all of you have independent contract agreements that address that. Virtually all of you treat agents that way. It's effectively the standard in the industry in Arizona and across the country. For the most part, agents are not W-2 employees. They can be, but for the most part, they're not. The business model is they're not. So that begs the question, are non-licensed assistants going to receive that same treatment? Do they meet the Internal Revenue Code requirements to be treated as a non-licensed employee, or as a non-employee effectively? The answer is no, and if you think about it, they miss the first two requirements. Number one, they don't hold a license, so under the IRS code, you're out on that. And number two, substantially all compensation cannot come from sales or output because the department says otherwise. So non-licensed employees do not meet the definition, cannot be treated like independent contractors. What's that mean? Here's the tough part. Here's the things that people don't like my answer on. Must the broker or team, whatever the case may be, withhold on a non-licensed assistant? Short answer is yeah, they should. If you want to get aggressive, go see your CPA, maybe there's some other technical IRS loophole you can work through, but I'll tell you, the specific exemption allowed in the Internal Revenue Code, those folks don't fit under. So whether the broker's paying or the team or the licensee is paying, somebody needs to be doing the withholding, and there's two things associated with that. Number one, it's a pain in the backside. It's detail, it's a lot of work, and you're going to have to pay. You can pay a payroll service, you can pay somebody to do it, but it's going to take you more time and probably more money to perform the service and do the arithmetic and the accounting. And the other thing is you got to match. You know, the FICA withholding and the Medicare, Social Security, it's about 3% that you have to match. So you withhold, if you got $1,000 paycheck, the agent nets, let's say $700, but it's going to cost the brokerage firm $1,200 because you got to match the withholding. So it costs more money. So people don't like the answer when I give it to them. But again, non-licensed assistants, somebody needs to be doing the withholding.
So we have a question.
Okay, let's do
right.
that. Yeah, I'm sure you don't like that statement. I'm sorry.
It's a long answer.
Yeah.
So what about virtual assistants that work on a project basis?
Good question. If it's a virtual assistant that works on a project basis, and talk to your CPA, because I don't want to purport to be a CPA. If you are not dictating means and methods, if you're not telling them how to do it, when to do it, what to do, and they're also a third-party vendor. They're doing this for other brokerage firms. There's a very good argument that you can treat them as a normal vendor and you don't have to do the withholding. If the person only works for you and is limited to your brokerage firm, and you tell them when they have to do it and how they have to do it, you're going to run into some issues. So it's kind of a continuum. It's all sort of what level of gray you're comfortable with. But again, recognize third-party vendor that provides you the service at their discretion, how they want to. You should be okay, but again, confirm with your CPA, because that's going to be arguably an issue if the Internal Revenue folks are looking at your books and records.
Okay, so does it matter if your virtual assistant is a person versus a company?
The better option short answer is no, provided that the person has a business where they do that for other people. So they're truly a third-party vendor. They're not just your effective employee disguised as a third-party vendor. So if they're doing it as a regular basis for other people, other firms, probably going to be okay. But again, it's really a continuum, and where you fit and how much work this person does is going to be where it falls. There are some national providers or some statewide providers that if you use them to organize your files and dump things in SureClose and get them in the right sort of status, yeah, that's going to be payment to a third-party vendor. You're going to be fine. But again, if you've got someone working out of their house and they work only for you, looks like a duck, talks like a duck, quacks like a duck, they're probably going to be treated as an employee. You're going to have to do the withholding. Right, and one more piece. So remember I talked to you about we had IRS issues, and we also have Department of Real Estate issues. Let me tell you about the Department of Real Estate issues in terms of this payment issue. The question really is, who pays? Does the brokerage have to pay, or may a team pay, or may an individual licensee pay? The commissioner has stated several times that all compensation needs to come through the broker. The language there is very broad, and if you drill down and think about it, I'll tell you what the real answer is or should be. All compensation for real estate activity needs to come from the broker. Remember we talked about the slide earlier. A licensee may receive money only from the broker with whom they're licensed, and only a licensee may be paid for real estate activity. So if the person is performing real estate activity, remember that big list of 32, 21, 01, 48 that we talked about? Listing, attempting to list, negotiate, attempting to negotiate, collecting rent or attempting to collect rent, etc., etc., etc. If the person is doing that sort of activity, then the broker must pay. Okay? If the person is doing something else, something outside of that universe defined in the statute, then the broker need not pay because it's not real estate activity. So back to where we were, if it's a non-licensed person and you are complying with the law, then that non-licensed person may be paid by someone other than the brokerage firm. And again, it's logic by exclusion. The reason for that is because they're not performing real estate activity. If they don't have a license, they can't perform the activity. Therefore, compensation does not have to come from the broker. So that's the other question we get. And again, Commissioner Lowe has made the statement several times in open forums that all compensation must come through the brokerage. That's true for compensation for services based on real estate activity, not true for unlicensed activity. That begs a question now. What the heck is unlicensed activity? What can we do? What's left? After 32, 21, 01, 48, what in the world can we do? Well, believe it or not, the department has given us some guidance, and it's been in place for 15 years. There's a substantive policy statement at ADRE.gov, I think is a website. If you Google Arizona Department of Real Estate, you'll get to the website. And on the left-hand margin, there's a click for substantive policy statements. You can click on that. Drop down there, and policy statement 2005.04 is identified. And that's what's on your screen. That's a portion of it. There's a little bit more, but most of the policy statement is on your screen. So what may an unlicensed assistant do? perform telephone duties, answer the phone. No, Mary's not here today. Can I take a message? That obviously. They can collect demographic information, solicit interest in engaging services of a licensee, so they can do some of your cold calling. I'd be careful there because there's a statute that says they can't do that. So to some degree, the statute and statute 3221-0148 says they cannot do that. So I'd be careful with solicit interest in engaging services of a licensee. Set or confirm appointments, yes, they can do that. Confirm appointments to list or show buyer with loan officer, inspector, repair, maintenance, or appraise. That's all. No discussion of merits, no discussion of substance, no discussion of anything relating to the transaction. They're merely a facilitator, merely administrative. They're not giving any sort of information. They may also call a mortgage and or title company to track the status of a file. Kind of a red herring here, or at least something to be aware of here. Does that mean they can dive into loan requirements, dive into easement issues, dive into what Schedule B looks like? No, only administrative functions, not substantive, just administrative function, i.e., do we have a loan approval for Mary? Yes or no? Report back to that. That's all they can do. Assist a licensee at an open house. That's a tough one. If I'm a broker, I don't let my non-licensed people go to an open house, but by this policy statement you may. The reason I wouldn't let them go is because you're going to get yourself into a tough position. If the unlicensed assistant has on a badge that says I'm with XYZ Realty, members of the public walking through are going to assume they can answer questions. They're going to ask questions. If your agent answers, they've practiced real estate without a license, they have trouble. If the agent doesn't answer, if the person does not answer, then they're going to be a PR disaster for you. They're there on site looking like one of your agents, but they can't answer the question, so what good are they really doing there? So I have a problem with that. Maybe they bring the food, maybe they open the door, maybe they turn on the fans or whatever they need to do, but being there and being visible during an open house, I think, is a tough one. But again, by the policy statement, you may do that. Unlock a home for a licensee, that's easy, pretty simple, very functional, very perfunctory. Deliver documents. They can take documents to a buyer or seller. They can arguably, and not arguably, if they're a notary, they can notarize documents. Again, sort of a sticky wicket there, because if they're notarizing documents, inevitably the buyers or sellers are going to be reading the documents. Inevitably, they're going to be asking questions about the documents, and then you've got a non-licensed person kind of put in this awkward spot about, well, I know what it means, I've seen this 100 times, but I don't have my license, so what do I do? So that's what the policy statement says. If you look on page 2 of the policy statements, there's a laundry list of things that they cannot do, which I'll run through just quickly. And again, this is all on adre.gov if you want to look at it, but a non-licensed person may not host an open house, pretty obvious, for the reasons I talked about earlier. An unlicensed person may not perform a walkthrough. An unlicensed person may not answer questions about a real estate document. And an unlicensed person, here's the one that's a little bit funky, may not give instructions to a contractor, appraiser, or a home inspection in terms of what they should do. So they can open the door and say, okay, inspector, have at it, do what you want. Open a door, okay, general contractor, have at it, do what you want. The general contractor is the more difficult piece, because what if the general contractor says, I don't understand what you want me to look at. I don't understand what you want me to bid. Once that non-licensed person starts saying, well, we think there was a leak in the bathroom and we need you to confirm the leak is gone, and also at least take a look at the drywall to make sure it's not still wet. Maybe we need a mold inspection, so on and so forth. Once the non-licensed person starts down that path, they're practicing real estate. So I would be very careful about having a non-licensed person work or give instruction with a contractor. Do you have a question?
What about activities such as preparing marketing pieces, maintaining databases, things that do not involve client contact?
Very good question. And let me do that in two pieces. Databases, for the most part, that would be fine. maintaining databases of property information, client information, whatever that their folks are doing in-house, not interfacing with the public. They're effectively collecting and organizing data. That's fine. A license is not required. What was the second piece?
With marketing pieces, preparing marketing pieces.
Marketing pieces is a little more difficult, and again, all this stuff is a continuum. So I don't want to give you the weasel answer of, probably, probably not. It's a continuum. Yes, they may put together materials. They may help with concepts. They may, think about it. Your advertising folks in general aren't licensed, but if they're specifically or have exclusive authorship of something, 2,200 square feet, 4 bedrooms, great neighborhood, so on and so forth, and they're putting the substantive data into the marketing materials, that's a problem. They need to get the data or the substantive marketing from the licensee. So if it's merely a function of putting it together, yes, fine. Coming up with the original concepts and drafting, going to be stepping your toe over the line, so probably not, or no, not probably not. They should not do that. And remember, for the marketing in general, there's a catch-all for the DB. The designated broker has to approve all marketing in any event. So if you work on it as a team and the licensee says, okay, let's get this 3-bedroom, 2-bath property in North Central Phoenix on the market, here's the price, here's what I want you to highlight, here's what I want you to do, and the agent does that data entry and puts together a flyer with the pictures, that's going to be okay. But again, if they're doing all of the data themselves, they're looking at tax rolls, they're looking at square footage, they're deciding, they take the pictures, decide which ones to use, all of that stuff, that's going to be marketing and advertising. And again, if you flip back to 32210148, that's going to be something that requires a real estate license.
Wow.
Yeah.
So not putting the data into the MLS.
Should not. If the data comes from, here's where it's a very fine line in terms of distinction. If the data from MLS comes from the licensee, the non-licensed person may be a data entry source and do the work. If its original authorship comes from the non-licensed person, then again, your marketing, your advertising, you're using your discretion to decide what to say and what not to say, and that becomes an issue. So think of it this way. If the person is exercising discretion, if they're deciding what to say, not to say, what to put in, what not to put in, that's something more than administrative sort of assistant. It's something that requires some actual independent thought, for lack of a better word. You're going to need a license for that.
Wow.
Yeah, that's why that statute's so big. That's why I started with what it covers. So I've got a bunch of questions on the next page, I think, and I'll go through these. Are we okay for time? What do we have?
We're doing
for time?
good. You have about 20 minutes. You're doing good.
Okay. So the questions, these are not specifically addressed in the statute. They're not specifically addressed in the administrative code or the policy statement. So I wrote them down and put them on here so we can kind of discuss what they are. Answer questions about fair market value. Yes, no, maybe. Tough one. I will tell you that a lot of non-licensed persons do. I can tell you that they give kind of offhand advice, and I can tell you that that's a violation. If you think about determining market value, that requires some discretion. That requires some independent thought. That requires somebody to look and say, okay, this property sold for X, this property sold for Y, this property sold for Z. Those are bigger, smaller, whatever, price per square foot, adjust for condition. It's going to require some analysis in terms of what the person's doing. So that's not specifically addressed in any of the department position. However, they need a license. So answering questions about fair market value, that's something a non-licensed person should not do. And the next question is a subpart of that. Answer questions about comparable properties. Goes into the valuation process, requires independent discretion, independent thought. And what if they, the typical question is, yeah, I see the house sold down the street for $242 a foot. My house is a lot nicer, don't you think? Can't I ask $265 a foot for my house? Those are the kind of questions that, again, are going to require that non-licensed person to exercise some discretion, to make some judgment calls, and that's the type of activity that a real estate license is required. So answering questions about comparable properties, I would say no. Very basic public information. When did it close? How much did it close for? That's okay. You can do that. That doesn't require independent thought. But if you're going to give an opinion or a thought on a comparable or something in the neighborhood, buyer or seller, I use a buyer advice, but seller can say the same thing. Mine's at, why you tell me to list at 240 foot when my neighbor sold at 265? Answering that and saying, well, your neighbor had a nicer property, they had a pool, they had a bigger lot. That's something that the licensee should address, not the non-licensed person. Square footage, a little bit easier, I think. Square footage, for the most part, is going to be something that's available on the tax rolls. Obviously, sometimes not accurate, but at least available. So what's the square footage per the tax assessors? Can an agent answer that question? Doesn't require discretion. They don't have to think. Yeah, they can. Related to that, what if there's square footage established by an appraiser? Same idea. Can they answer that? Probably yes. Not ideal. I would prefer that a licensee answer the question, but they're not using any discretion, independent thought. They're just conveying data. That should be fine. Measure square footage, kind of the flip side of that same idea. No, absolutely not. They should not. And if I'm a broker, I have a policy where my agents don't measure square footage either. That's not something you want to be involved with. Appraisers will measure square footage. Let buyers measure square footage in whatever method they want. But if I'm an agent or if I'm a broker, I don't let my agents have tape measures in their car. If they want to measure the inside to see if the couch is going to fit, fine. But to measure the exterior to compute square footage, non-licensed folks cannot do, should not do. Licensed folks could if you're a broker and going to allow them, but I wouldn't. I would have a broker policy saying, no, that's not going to happen. Next one is discuss neighborhood demographics like race, gender, religious preference, age. That's a bit of a trick question. Can a licensee or a non-licensed person answer any of those questions? The answer is no. That's going to be a fair housing violation. I'm Irish. I want to live by all the Irishmen so we can drink beer. Is that an okay question? No, it's not. You can't go there. You can't base your information on anything prohibited by the Fair Housing Act. So race, gender, religious preference, age. In some cities, Phoenix, Sedona, Tucson, sexual preference, gender orientation, also protected classes. So, is there a strong gay or lesbian community here? Again, in Phoenix, that's a fair housing violation. You can't answer that question. So that's a no-no. That's a no-no, the licensing issue notwithstanding. Discuss negotiation strategy. My house is listed at 275. The offer is 250. What do you think? Should I counter at 274.5? That's something that is specifically addressed in the statutes. That's something that a non-licensed person specifically cannot do. Again, sometimes buyers and sellers are very anxious to understand or to get information. Sometimes that the licensee is out and about. There's going to be a temptation on behalf of the licensed or non-licensed person to say, okay, Fred's not here. Here's what we typically do. Here's what I think we should do, but let's wait and talk with him. Seemingly that's okay, but I wouldn't do it because you're still giving advice. And what if the buyer seller never hooks up with the licensee? They base their negotiating strategy based on what the non-licensed person said to them, then you have issues. So if I'm training, if I've got a wish list for my brokerage firms, I'd say no, we're not going to talk about negotiation strategy at all. Not even what they typically do, just no. Non-licensed persons cannot talk about negotiation strategy. Answer questions about contract provisions. This is probably one of the more common areas that we see, and especially if the non-licensed person is a notary, so they can go out and get signatures. Inevitably, folks are going to ask questions about contracts. In addition, even if they're merely delivering documents for signatures, think about this scenario. They've got a half a dozen documents that need to be signed as part of the process. For some reason, their printer doesn't work, or they can't get email, or they're technological idiots like me and can't print something or use DocuSign. The assistant says, you know what, fine, they're 10 minutes away, I'll jump in my car, I'll go get these folks to sign, I'll get the signatures. That's a good customer service exercise. That's going to make your clients happy. However, that's going to be a recipe for a problem, because inevitably there are going to be questions. What does this mean? What do you mean I'm holding harmless the broker for anything they may do? Why is this in all capital letters? Why is this all bolded? Why do I have to initial here that I'm going to hold the broker harmless? What's the square footage mean? What's a termite inspection? What's all the things that people that don't do real estate every day, i.e. most of your clients, all the questions they ask, they're going to ask your non-licensed assistant because they're going to see the badge of XYZ Realty. They're going to see that they work for the company. They're going to assume that person knows the transaction, knows the contracts. You're going to get yourself in trouble. So again, I would not, for the most, unless you have no other option, send your non-licensed person to collect signatures, and bear in mind they need to be trained pretty aggressively. Do not answer questions, even if they know. They're going to know what those provisions mean. If they've been with you for a long time, they're going to have closed dozens, maybe hundreds or thousands of transactions. They're going to know what provisions mean, but they can't answer questions about those. Title commitments, same idea. Schedule B docs, easements, what those mean. Those are things that we in the industry know about. Those are things that John Q. Public does not. So there are going to be questions about title commitments. What's this Schedule B document mean in terms of the CC&Rs? What's a CC&R? Why can't I put my boat in the backyard? What's up with the swing set? What's up with the basketball hoop? All the things that buyers, sellers are going to want to know about. Again, the non-licensed person is going to want to answer the question. They're going to know the answer, but you can't do it. So no questions about title equipment. Steer clear of those. And then a related question. I actually have a case about this right now. Discussing easements and whether structures can be erected on an easement. Let me back up and give a tip to the wary. Make sure you have your agents look at Schedule B docs. If there are easements, make sure they open up and look at the easements, because sometimes, and I'm defending a case like this, sometimes buyers have plans to build a pool, a casita, whatever, on the property, and if there's an easement running through or across the back 25 feet of the property, they're not going to be able to build what they want to build. I'm defending a case right now where a non-licensed person answered questions about an easement and effectively said, no, you own all the way to the fence, you can do whatever you want there, and come to find out the easement precluded construction. So the casita they thought they could build to put mother-in-law in the backyard in her declining years, they can't build. And I'm defending on two problems. Number one, I've got a non-licensed person who gave advice, and number two, they gave bad advice. So pay attention to the easements, and if you can, well, not if you can, as a broker, make sure you have a policy that non-licensed folks don't talk about those issues, because easements are kind of a hidden gem for plaintiffs' lawyers. So be careful of those as well. Now, next one, arrange for and direct improvements or repairs. And there's two time frames associated with that. Number one, before the listing, and number two is during the Benzer process. And both of them are no-nos. If you're going to tell a handyman or a general contractor what to do, which areas to fix, which areas to look at, that's something that requires a license. That's something that you need to hold a license to do. Next one, I've got a case like this where discuss traffic patterns and noise. Is a house close to the 101? The licensee wasn't in. They asked a non-licensed person, well, what do you think? Is traffic noise going to be an issue? The non-licensed assistant said, no, I live fairly close. I don't hear a thing, not a problem. That was their own personal belief. Come to find out, this buyer can't stand the traffic noise, and we're getting sued. The brokerage firm is getting sued over that. And again, non-licensed person, even using their own personal observation, saying, I live here, doesn't bother me a bit, something we're defending. And again, I've got the idea where a non-licensed person answered a question they shouldn't have answered. So you can get stuck in a lawsuit over that one. Another one, pool barriers. As you know, there are, 7, 8 different municipalities. A lot of them have different pool barrier ordinance requirements. Non-licensed folks cannot, should not talk about those issues. Again, requires interpretation, requires discretion, requires independent thought. That's outside of their jurisdiction in terms of non-licensed persons. Can they provide the statute? Can they provide the city ordinance? Yes. They can grab a copy and email it. That's fine. Interpreting it, saying what it means, that's not fine. Okay? I think I got one more. Arrange a home inspection and unlock the door upon arrival of the inspector. That's okay. That's purely administrative. They're arranging, they're scheduling, and they're unlocking the door. That's acceptable if they tell the home inspector, hey, looks like there's a couple tiles broken and I saw a stain on the ceiling. It's like water. Will you look at that? No, that's going to require some discretion, independent thought. You need a license for that. So they should not be doing that as well. All right? More questions? If you have something specific, tell me. That the list of these things is absolutely exhaustive, exhausting. You can't get them all because something always comes up. But if you have anything specifically you want to talk about, please tell me. And if not, we'll go to our next poll question.
All right, we're going to go ahead and open up the poll so while you ask your questions. So our second poll is, may an unlicensed assistant or unlicensed employee be a member of a real estate team and be paid by the broker as a member of the team? Yes or no? I'll say again. May an unlicensed assistant or unlicensed employee be a member of a real estate team and be paid by the broker as a member of the team? And team's another very hot topic.
It is. It is.
So, because we have a little bit of varying answers here, why don't you hop in on the answer?
Sure. The answer is no.
No.
The Department of Real Estate requires that all team members hold a license. So if you're going to have a team, your team must consist of real estate licensees. You cannot have a non-licensed person on the team. So that's the answer. The reason the answer is no is because unlicensed folks cannot be on the team. And that applies to owners too. In fact, I dealt with this with DRE as well. There was an owner of a brokerage firm who was out of state and also wanted to align themselves with a team, but didn't hold a valid real estate license. We received a complaint from DRE and had to defend, and the basis was, and the commissioner took the position, was right. We had to disband the team and retool, that all team members must hold a license. So unlicensed folks cannot be on your team. They can be part of your group. They can be part of who works with you, and you can identify them as, my assistant Johnny or Jill or whatever, but you can't market or advertise those people as a team member because they can't be. And in addition, you can't pay them for closings. You can't give them a commission or incentive based on the number of closings. Remember, we have to be hourly with non-licensed folks, because if you have the incentives in there, it's going to start looking like a real estate licensee. You're paying like a real estate licensee. You're potentially going to have problems with the department. Somebody doesn't like that one either, right?
Oh my. So thinking about hiring a phone assistant to follow up on leads, is it okay to ask the lead what time they have an opportunity to talk to the agent? Or, and then the next question, if we can forward their information to a lender partner?
Asking for appointments, yes. Forwarding information to a lender partner, no. I think I read that as asking for permission to do that. A little bit of a gray area, but as long as the member of the public, the buyer-seller, is aware that they're providing information to a real estate licensee, buying through the non-licensed assistant, and then it's going to be processed or handled by the real estate licensee. Close call, but I'm going to say that's okay. The licensee can ask for that permission. The actual activity that requires the work and getting it out and discussing loan application and that sort of stuff with the broker, that's a no.
So one of the questions is, you have a team, and I used my little air quotes,
right,
and you have a personal assistant who is an unlicensed assistant. So you're going and you're having your team pictures taken. Is your personal unlicensed assistant in the picture?
No, I keep them out of the picture, because I assume you're going to use that photograph as a marketing tool, and I assume you're going to disseminate that to consumers, and that's going to be misleading because you're going to be representing your team as consisting of 7 people when it really consists of 5 and 2 assistants. So I would keep them. out of the picture. I know it's exclusionary. I know that you want to make people feel like they're part of the pack. However, if they don't have a license, you can't effectively advertise them as part of your team. Questions on the hotline, they don't like that answer either. And introducing the assistant as part of my team or my team member also don't like that answer, but that's the way it needs to be. They need to make sure they're real clear in terms of what role this person is performing, and they can't be a part of the team really by DRE rules and regs.
Wow, that's eye-opening.
Yeah.
Okay, so the next question is, going back to paying the unlicensed assistant, you have a brokerage that has one person doing the transaction coordinating or the marketing part of it, and you have several agents sharing that person, and that person's unlicensed. So who's responsible for paying the taxes on that one?
Effectively, well, there needs to be an agreement amongst the brokerage and the teams to decide that. Somebody needs to, and the responsibility to pay the taxes would go pro rata with the amount of money they're being paid. If I'm running a brokerage firm and I'm performing that service and hiring a transaction coordinator or somebody, I would take it upon myself as a broker, because the buck stops with me as a broker, take it upon myself to pay them and then collect the money, including the withholding money, the extra 3 to 4% from the licensee, so then you can collect it and pay under typical payroll processes. If there's a person that's shared, there's no rule or reg that says exactly who should pay and how much, but just the rule of reason is it should be pro rata based on the work they're doing for each particular licensee.
Okay. So, and then the next question, can an unlicensed assistant give the list price of a property to a licensed agent or to a potential buyer that maybe is calling in for sale or a lease sign?
I would avoid it. You're answering price questions, and it's a distinction really without a difference, and I acknowledge that. But what I would train my non-licensed folks to do instead is say, I have the MLS, can I forward you a link? And just leave it at that. And it's going to be a little bit evasive, so I'm going to say, I don't want the link, I just want to know how much a darn thing costs. And that's when they need to be a little bit delicate and say, I'm sorry, I can't, that's a price issue, I can't answer that question, I have to get you to somebody else. It's, again, a distinction without a real difference, but if you want to be clear and keep yourself out of the lovely offices down at 44th Street and Thomas, I would say no.
And this definitely does seem to be a hot topic right now.
It is. It's something they're pretty aggressively looking, because I think a lot of people don't know. I think a lot of people are super busy and they need help. Mm-hmm. And it's real easy to delegate, and if you delegate and can't only hire somebody good who's going to take the reins and do things and have their own initiative, you're going to walk into a DRE problem.
So probably like we talk about the risk management part of it, knowing up front, and the risk of your decisions.
Right, exactly right. And again, it's one of those, and I use an analogy in my teaching. I drive to Tucson 3 or 4 times a month. The speed limit's 75. I drive 82. I set my cruise to 82, and I go. I never get caught. Knock on wood. I never get caught, but I'm breaking the law. If you have your licensee do these things, you may never get caught, but boy, if you do, you got a pretty clear violation. You got some issues. So it's a risk reward sort of thing. It's also, boy, if I'm a broker, I'm going to have pretty hard and fast rules and hope that my licensees follow it, because if you have more than 5 agents, you're not going to be able to monitor what they do all day, every day. So again, hard rules, enforce them the best you can, and hopefully they all stay between the ditches, if you will.
And of course, if you have specific questions, and everything is just muddied up and chaotic, best thing to do is call you.
Yeah, call the hotline, call me personally, either one. I'm happy to help and walk you through it. Some of this stuff is counterintuitive. Some of this stuff doesn't make a lot of sense. I acknowledge that. But again, I didn't write the stuff. I just get to interpret it and tell you guys about it.
What are the hours on the legal hotline?
Hotline is open from 9:30 to noon and 2 to 4:30 every business day. We're not open on the weekends, but it's that 5-hour block during those time frames.
And who can call the legal hotline?
Brokers, designated brokers, and/or someone they designate. You can't, random agents cannot call. It has to be the broker or someone they designate. We have roughly 40,000 realtors, and there are probably, I think the last count, 4,500 people have access to the hotline. So it's not everybody, but if you're a licensee, your broker, I almost guarantee you has access to the hotline. If not, all they have to do is sign up. It's part of the membership benefit. There's no cost. Sign up, and then your broker can have access. And a lot of times, agents will sit in the room with the broker during the call so they can hear what we say, help fine-tune the questions, and get to the right answer.
And if you're taking 400 calls a month, people are calling. They do have questions.
Yeah. Oh, there's lots of questions. Yes. Yes. Lots of real estate activity out there and lots of questions.
Excellent. Very good. So Rick's contact information is on the screen. He does prefer Rick to Richard, but
either way
is good. Phone or email better for you?
Both. Probably email, because I'm out and about a lot, so phone is sometimes hard. Email I get to, I can see from my phone, so email's probably better. But either one, I'll respond to. And I have a really good assistant.
Yes.
Who can follow up as well.
Absolutely. Absolutely. Next time, Rick, let's talk about the whole W-9 1099 thing.
Okay. Deal.
Okay.
Deal. That's a tax issue, and yeah, absolutely. We'll do that.
That would be really good information. Thank you, Shane, for that. And then just because everybody on the call today are brokers, owners, managers, we have Brokerage Revolution coming up in January 11th. And this is $25. It's over at the Scottsdale Association venue, 8600. And this is like a program like no other program. And I know you've heard me say that before, but I really mean it this time. It's not just about management. Carol Murray, who is a national speaker, is going to join us, and she's going to talk about how to be an exceptional leader, coach, strategist, and give you some really hard and fast tips to grow your brokerage. And so I just wanted to put that out there. It's now available on the calendar at aaronline.com. And then our first webinar of 2016, we are going to talk property management. Isn't that exciting? I got to tell you, folks, Denise Holliday, attorney, and Mike Mumford, property manager, are going to be joining us, and we're going to cover the 10 hottest property management topics in 2015. And I know we had a new disclosure come out this morning about TPT going into effect in January. So we're going to talk about that. So if you have property managers in your brokerage, we do absolutely encourage everyone to join us. This will be really good. And as I mentioned earlier, today's webinar has been recorded and will be available on our website. We have about 25-ish webinars currently available. So with your morning coffee, you can jump online and learn more about TRID or building teams. We have lead generation, lead conversion, all really excellent topics that our members have suggested. We do have a full service, the Broker University webinars as well. So folks, thank you so much for joining us today. Rick, any closing comments?
No, thanks for paying attention. I know that's a real sort of fine-tuned discussion, and I appreciate the attention.
Okay, well, thank you very much for joining us, folks. With 14 days left in 2015, make the very best of every single one of them. Remember, don't take Fridays off. And thank you so much for joining us today. And Rick, everybody is saying thank you, thank you, thank you. Trudy Moore and Jim and Brian McMahon, thank you so much for joining us today.
Thank you for the time.
Thank you, folks, and have a great day.